So we will start. That's okay.
I'll just introduce you.
Yes,
Good morning, everyone. On behalf of the Moot Court Association of Government Law College, Mumbai, I'd like to welcome you to our meeting workshop on constitutional law. Thank you for joining us today. Our esteemed guest for today is Mr. Agastya Sreenivasan, an alumnus of Government Law College, Mumbai, from the batch of 2021. Mr. Sreenivasan is currently an associate at Solomon & Co. And during his mooting days, he was an avid mooter with an extensive record, such as having participated in numerous prestigious moot court competitions such as the Surana and UPS School of Law National Insolvency Law Moot Court Competition, the International Criminal Moot Court Competition, the 3rd National Moot Court and Judgment Writing Competition, and the 5th NLIU Justice R.K. Tankha Memorial International Arbitration Moot 2020. Mr. Sreenivasan has also secured podium positions in the International Law Grand Moot Court Competition 2018 and the Grand Moot Court Competition 2019. Additionally, he has also judged several moot court competitions hosted by our college. Drawing from his vast experience both as a participant and as a judge, Mr. Sreenivasan will provide us with invaluable guidance and share insights into the subject of constitutional law. Further, he will also advise us on the fundamentals of mooting. I'd like to invite Mr. Sreenivasan to preside over today's session. Thank you.
Yes, please ask. So, before I begin, I think what may be very useful is if I may get a show of hands to understand who is in the first year. Sizable of the 3-year course or 5-year course? 5. Yeah. Then who are in the second years or beyond? Oh, also a fair bit of people. So let's do it this way. We'll approach this one by one in terms of, because it's a workshop, it's not a lecture. So what we'll do is we'll start with the fundamentals. You would have studied in CLAT, MHCP, some things. You would have some vague idea about constitutional law at the very least. So we'll begin from there. And then we'll go into the aspects of mooting as well as aspects of constitutional law that we need to be aware of. So, would anyone want to volunteer on what they understand by constitutional law in the first place? Just anybody. It need not be the right answer. I'm not taking a viva. This is just to get our brain working. It's early in the morning. And to ensure that we can think of a lot of these doctrines which have been developed over the years in a fresh perspective. Because when you think of it and then you realize, oh, the judges have come to the same conclusion, then it stays in our memory for far longer. So, would anybody want to hazard what they understand by constitutional law? What is a constitution? Yeah, go ahead.
Law made by the constitution is called the constitution.
But then what is a constitution?
It's a set of laws and guidelines approved by the state.
So, what's your name? Abhinav. Yeah, nice. So we start off here a set of laws defined by the state. Is that enough? Is there something missing? Somebody wants to add something? The Indian Penal Code, or the Bharatiya Nyaya Samhita now, is a set of laws passed by a state. Is it a constitution? So what's different in a constitution?
It is a principal guiding document which helps us form all laws in India.
Slightly better answer. I think, not to delve too much time on this, but generally what we consider as and I think what we might benefit from is looking at the arguments in the Article 370 case, where they spoke about the Constituent Assembly of Jammu and Kashmir and the Constituent Assembly of India versus the Parliament of India and the Legislative Assembly of JNK. The constituent power is like a plenary power. It's unlimited power, blank canvas. You can do what you want. So when we formed our Constituent Assembly in 1946, We could have chosen a presidential form of government, as in the United States. We could have chosen to replicate exactly a unitary system as followed in the United Kingdom. We could have done something similar to what Australia has done, something to what South Africa has done. And so, one of the advisors to the Constitution Committee, by the name of B.N. Rao, traveled across the world and compiled, of course, from different areas, ideas, good ideas which he felt to be incorporated in our Constitution. And then our Constituent Assembly, using this plenary, extensive, unlimited powers, gave unto itself and to the people of India our Constitution. And we'll notice this distinction between constituent power and legislative power as something that courts have tussled with and interpreted at great length over a period of time. Would you have a copy of the Constitution? No? That's fine. Later on, just have a look at Article 13. Article 13 actually defines, so I'll take you through a broad history of how law has come to be defined and a couple of, I would say, broad trends. So once you understand the broad trends of the Indian Supreme Court, when you approach any constitutional law problem in India, you will think of it from a very different perspective. Now this is a purely subjective classification that I have made. But if you broadly define Indian Supreme Court and the history, the first major classification is from 50 to 77, where most of the constitutional law problems dealt with how to address fundamental right violations and how to address property rights. So just people have ideas, because I want to get into, people have ideas of what our fundamental rights are. Would somebody be able to help out and say them what they are, just broadly? Right to equality, 14 to 18. Right to freedom of speech, 19. And other freedoms, freedom to travel, freedom to assemble peaceably without arms, all the postal rights under 19. 21. No person shall be deprived of their right to liberty or life except according to procedure established by law. 22 is about preventive detention. 20 about you cannot be forced to testify against yourself, and also a couple of other things like double jeopardy. 23 covers 22 covers forced labor, etc. But these are the broad fundamental rights. Now what happens if somebody violates a fundamental rights? What happens if the state violates a fundamental rights? What do you do? What's the remedy? Writ petition. What is your authority of final writ petition?
Article 32 and 226.
What is Article 32 and 226?
Right to constitutional evidence.
Yes. And go back and look at 32 with a copy of the Constitution. You will find it very interesting. It says the right to approach the court to secure fundamental rights is guaranteed. You will find no other article in the Constitution, probably anywhere in the world, which uses this expression, is guaranteed, which means that it is one, of course, your fundamental right to approach the court, because it's a fundamental right in and of itself. Dr. Ambedkar called it the soul of the Constitution. But beyond that, it is mandatory. Once you approach the court, the court cannot say, well, go to the high courts first, etc. They have to consider. Although in practice, in the recent past, judges have said in Article 32 petition, first go to the high court because the Supreme Court is clogged with too many cases. But in principle, the right under 32 is guaranteed. Then there is 226. What is 226?
Petition to the High Court.
And when you file a writ petition to a high court, what kinds of rights are violated? Is it only fundamental rights? Is it other rights? all the rights under the constitution. Yes.
Under 226, the court can grant any right for any purpose.
Yes.
So that is the wording as 226 reads. So a person or a litigant can file a 226 petition for enforcement of any right, be it in the constitution or outside.
So let us say I enter into a contract with you and you violate the contract. Can I file Article 226 petition?
I'd say no, because a check first would be, is that a state entity under Article 12? If it's a private entity, you either do under specific performance using the contract right. But if it's a state entity, you do under Article 12 because it's considered a state. So my answer would be 226 is only applicable or can be enforced against an authority which is a state.
Interesting. So for others who are or are not aware, are you aware of Article 12? You are aware. So Article 12 uses the expression state and also uses the expression instrumentalities. And this has been interpreted very interestingly. So first it said state can mean union government, state government. Then it said, well, what about BMC? BMC is under the state government. Let us say BMC went, for example, to Kangana Ranawat's office and home and said this is illegal. I want to demolish it. Could they do that? What if they are doing it out of spite, as a way of acting revenge, in a malafide manner? What remedy does she have? Can she approach the courts? Yes. So when she approaches the court, what will she say? This particular BMC is an instrumentality of state because it is a body that comes under the control of the respective state government. In fact, subsequently, courts have gone on to say that you can enforce 226 rights not just against instrumentality of state, but against private parties as well. And I will come to that. It's a very interesting set of judgments. But broadly, you need to satisfy that first, just to get our broad principles correct. You need to satisfy that this is a state or a body which performs some function akin to the state or is under the control of the state. State meaning either the central government or the state government. So just for starters, let us say there is a company which is 100% owned and controlled by the government, and that you basically carrying out functions of the government but in the form of a corporation. So when you're doing that, let us say they violate some fundamental rights. So let me give an example of LIC. LIC does not give you your premium. It is performing, when it was not listed, etc. At one point of time, the central government controlled some 90% or 95% shares in LIC. So somebody did not get their premium. They said this is a state duty. Insurance was considered to be, it was all the insurance, multiple insurance companies were nationalized. So they said that in such cases you can go and approach courts. Because at the end of the day, that is not a company. That is there is a company acting for the government. And therefore, if that violates my fundamental rights, I can go and approach courts. So the first major thing that we are looking at is this body a state or an instrumentality of state? This is very important when you come to any constitutional law problem, because you will be asked to satisfy this burden. If you don't satisfy this burden, you won't be able to maintain your petition. They'll say, please approach some other forum. This is not the forum for you. So that's the first thing. Then comes, let us say, taking this Kangana Ranawat example. BMC issues an order saying this particular, the Moot Court Association is being illegally constructed and without permissions from BMC, and therefore you are required to explain your actions within 30 days, otherwise we will demolish the Moot Court Association. So what do you do in this? What remedy do you have? Can you think? Would anybody like to think? It's an instrumentality of state, right? BMC, correct? So the answer is that you have to somehow hold the order that the BMC has given you to be void. You have to say that that is illegal. Correct? And then you will get your remedy. This will not be demolished. So how do you declare a law illegal? Would anybody want to? Because this is the next step. Whenever you approach constitutional courts, what are you asking for? You are saying that some action of the state is illegal. So how do you go about that?
That is unjust, arbitrary, and unreasonable.
Why? Why unjust, arbitrary, unreasonable?
Because according to the due process of law, any law that's brought in place has to be just, arbitrary, and fair and reasonable.
Oh, so let's hold on to that thought.
But I know that the Constitution does not mention due process of law.
No, one second, we'll come to that. So the first very important thing that needs to be considered is Article 30. Article 13(3) of the Constitution says any law, and law has been defined as an ordinance, as a statutory law, as an order, as a rule, a regulation, and I think the personal law and customs, where it says that any law which violates fundamental rights is to that extent void. Void means void ab initio, still void, dead from the beginning. It is as if it never existed. Okay? So the idea is anything that violates your fundamental rights, any law, is void. Now, how do you define whether your fundamental rights have been violated? This was a question that courts grappled with back in the day. And I'll be delving into some constitutional history to explain these principles. But the essence was, one of the first problems that the court came up with is how to understand your fundamental rights. So, one of the first cases was A.K. Gopalan versus State of Madras, where they said that one particular person was a communist. He may commit crimes in the future. So therefore, as a means of preventive detention, before he commits the crime, I will arrest him. So they arrested him and detained him. Now he said that my fundamental rights are being violated. My right to life and liberty, Article 21, my right to freely move about the whole of the country has been violated. So that is one of the first cases where Article 21 came to be interpreted. And what does Article 21 say? No person shall be deprived of their life or liberty except according to procedure established by law. Now they said there is a law. The preventive detention law is there. There is a procedure. You take this person, you arrest him, you show it before court, 3 months, 6 months, he stays in jail. So if there is a procedure established by a law and he is put in jail, Article 21 not violated. Seems reasonable. He said, but no, my Article 19 right has been violated. I can't move across the country. That's also not. Court said no. They said you can look at only one fundamental right at a time. You can't mix match fundamental rights. You can't say my 19 is also violated, 21 is also violated. They said it's all separate silos. So if your right to life and liberty is taken away and you put in jail under 21, procedure established by law, then you don't have any remedy. You can't say I am not allowed to travel all across the country and therefore my 19 right is also violated. This is important because if you were A.K. Gopalan, you don't have any remedy under the law as it existed in 1951. You can't go to court and say, please quash this. But then eventually, there was a very nice dissent in this. And I think there's a very nice lecture by Justice Winter Nariman which you should listen to. It's on YouTube. It's called, and of course he's written 2 books also on this. It's called Dissenting Judgments and Great Dissenters in Indian History in terms of judgments. whenever a dissent is passed, so you people are aware of what a dissent is, right? So India, how we write judgments, there are different ways of writing judgments also, all across the world. There are certain places where in the US you have 7 judges, 9 judges, 7 or 9. You have all judges of the court sit together. In India, that's not the case. In our Supreme Court, we sit in batches of 2, 3, sometimes even 1, 5, 7, 9, etc. And in India, we have a situation where each judge can pass a judgment of themselves, right for themselves. Certain other jurisdictions, like in France, the court speaks in one voice. So there is one judgment, that's it. You don't have majority judgment and minority judgment. You don't have dissents. You have court speaking in one voice. It leads to a lot of clarity. But there were a couple of great judges in the United States Supreme Court whom we took inspiration from. For example, Justice Brandeis, the US Supreme Court, and also I think Justice Holmes, who said that dissents are a brooding spirit of the future. So what may be a dissent today may 10, 20, 30 years down the line become accepted wisdom and may be accepted as the correct law. So in A.K. Gopalan, one of the dissenters was this man called Fazal Ali. Fazal Ali said, this doesn't make sense. Why should fundamental rights be compartmentalized? How can you say 21 is separate, 19 is separate, other articles are separate? After all, he enjoys all those rights together. And you must, in his view, look at them holistically. So he expressed doubts over this silos way of thinking about fundamentals. And eventually that came to be tested much later in what is known as Maneka Gandhi versus University, which many of you would have heard of in preparation for your CLAT and other exams. Where they said that expression that was there, procedure established by law, they actually went back and went through the entire history of how that expression came to be. That expression came to be because, as I said, we borrowed from all across the world. The US Constitution uses the phrase, no person shall be deprived of their life, liberty or property except by due process of law. Now what is this due process? Due process is what is due, what is the right of that individual. So every law that is there must be just, fair and reasonable is what the US court said. It can't be arbitrary. I can't just make up a law tomorrow saying that I want to arrest so and so, therefore I will make up a law. I will arrest that person. And it doesn't matter if the law is unfair. It's procedure established by law. And this distinguishes countries like the US and India versus countries like China. A lot of you would have heard this expression, rule of law. There is also another expression called rule by law. What's the difference? Anyone?
First rule of law is that the law precedes over everything and goes to
Yes, but not fully. What it means is, law needs to be just, fair and reasonable. It can't be arbitrary. And it must protect all sections of society. So, you must be aware in the preamble, we call ourselves a democratic republic. Why democratic republic? In fact, there is this very famous quote by Benjamin Franklin. He was stepping down as the US president. And they said, what is the legacy that you leave behind? He said, the legacy I leave behind is not a democracy. It is the fact that I have made the United States a republic. What's the difference? The difference is, democracy means if I have the majority, I can do whatever I like. I have 50 plus 1 votes out of 100, I can do whatever I want. But then there may be certain minorities. And I'm not just talking about religious minorities. It could be linguistic. It could be of community-wise. It could be so many various kinds of minorities. Minority in just thought, in opinion, in your views. people have different views. So a republic protects those who are not part of the majority. It is for the protection of the minorities. Because at the long run, it is foolish to have the majority and minority always fighting with each other. So in a country like China, in a country like maybe Iran or Saudi Arabia, there is rule by law. So once you pass the law, no matter how arbitrary, unfair, unreasonable it is, you have to follow. You have no choice. The citizen has to come. In a rule of law, you will examine whether the law that is being passed is good, is just, is fair, is reasonable. If it is not, you go to courts and declare it as violating your fundamental rights. And that is critical, because if we did not have this power, then we would become a state where you have authoritarian tendencies, dictatorial tendencies, much like former Soviet Union, China, etc. So this aspect of rule of law is very important. And the US had incorporated this in their due process clause. But what happened was that there was a whole host of judgments over there regarding minimum wage. I won't get into that today. But in that process, they said that what they mean is that the procedure by which you are depriving the person, it's not as if the judge is deciding on the merits of the law. The judge is not like a super legislator. Once you are aware of the doctrine of separation of powers. Legislature has its own duties, judiciary own, executive own. So it's not as if the judiciary becomes a super legislature and reviews everything that is being passed by the legislature. No. Nothing of that sort. What they intended to mean by the due process clause is that the procedure, whatever you are following, should be just and reasonable. You cannot do something just because you have the power of the police or power of the army. That, by the time the Japanese constitution came into place, which the US people drafted, the US people changed it to say procedure established by law. What they meant was due process, but concerning procedure. And so when we picked that up from the Japanese constitution and put it here, that is what we also meant. So by the time it came from A.K. Gopalan in 51 to Maneka Gandhi in 76, we had a tectonic shift by which we said that okay, let us restore back what we had lost and get it back to that due process. Which means if somebody is arrested illegally, you examine that law and the procedure prescribed by that, whether it's fair, whether it's reasonable. And if it is, then you uphold it. If it's not, strike it down. So, this is a landmark shift because every time you now test the law, you have to. So that is one. Second, Maneka Gandhi also rejected the earlier aspect of looking at fundamental rights in silos. It said no, you can look at 14, 19, 21 and other fundamental rights all holistically. Therefore, if something violated Article 19 but was meeting the requirements of Article 21, it would still be void because it's violating 19 at the end of it. It's not as if you comply with one and therefore it's valid. No. If you don't comply with any one of those fundamental rights, your law becomes void. Still void. So I think this is very important to picture in your. So this is in terms of the, and after that there are subsequent judgments which have repeated, reiterated what Maneka Gandhi said. So that is on Maneka Gandhi. Now another thing which is very interesting is what is law. This is a very important doctrine. This is what is known as the basic structural doctrine. And it comes up in multiple constitutional law problems, whether internally or even in some other moot court, inter-college moot court competition. Now, so far as that is concerned, What would you do? Yes. That is a very interesting relationship. Now, you people remember that I said Article 13 said that any law that violates fundamental rights is void. So, now came up a very interesting question. There is an article called Article 368 which talks about the amending power of the Parliament. What can the Parliament amend and what can it not? One view that was taken was that Parliament has unlimited amending powers. And because it has unlimited amending powers, it can do whatever it likes. The other view was that law as defined in Article 13 includes constitutional law. Makes sense? Law is of various types. Constitutional law is a form of law. So therefore Article 13 should include law. So law as defined in Article 13 should include constitutional law. But what does Article 13 say? Any law that is violating fundamental rights is void. So if the Parliament passes a law, even a constitutional amendment that is violative of fundamental rights, immediately struck down. Yes, two opposing views. So first, there was a case called Karak Singh. Sorry, Shankari Prasad. Shankari Prasad, I'll give you the citation if you want. Shankari Prasad versus Union of India, where AIR 1951 SC 458, where they said that nothing of this sort. Law, they basically said that Parliament has unlimited powers to amend. The law is defined in Article 13, does not mean the Constitution. But then subsequently, there was another judgment called Sajjan Singh versus State of Rajasthan. Now here's where things really get interesting. They said, Justice Hidayatullah said that, well, if I can amend fundamental rights, are they really that fundamental? Can't be. Fundamental means it has to be something set in stone. Otherwise, how is it fundamental rights? If I can just take it away. It's just about any other law. And for the first time here, in another dissenting judgment, Justice Mudholkar raises this. He says that, raises doubts. He says that there must be some basic feature of the Constitution which cannot be amended. So for the first time, this expression called basic feature or basic structure is introduced. Although it was not thought of, there is no concept in it. After Sajjan Singh, there was a very interesting lecture in the Banaras Hindu University by a fellow, an Austrian professor by the name of Peter Conrad, who had endured the Weimar Republic and Nazi Germany. Now, Peter Conrad came up with a lecture and a research paper which said, and probably one of the most influential research papers, which came up with this doctrine called implied limitations. Very interesting doctrine. It said that, okay, Parliament has unlimited powers, but not unlimited. It has certain inherent limitations. Which means what? It means that, let us say, and later on, Palkiwala, when arguing Nani Palkiwala, one of the greatest lawyers of all time, also an alumnus of Yale, also a teacher in Yale, he came up with very interesting examples during the question of the Palki case, when he was arguing this implied limitation doctrine. And it's very creative examples. He said, let us say, I remove the President of India, I pass a constitutional amendment, removing the President of India, and making a Prime Minister equivalent to the President, like a presidential system. Would that be valid? Let us say I remove the President and make the Queen of England or the King of England as the monarch of India. Would that be permissible? Can the Constitution allow such kind of an amendment? Let us say I make the term limits of the Parliament from 5 years to 15 years, to 20 years, 50 years. Would that be valid? Of course, you can say no. You can amend the law. You can amend if Parliament's power is unlimited. Can you do these amendments? logically one aspect says if it's unlimited they can do whatever they want. But somewhere we feel common sensically no. And here is where Patiwala used the expression defaced and defined. He said that the power of amending is to amend. At the end of the day, the constitution must stand. It cannot be defaced and defined. It cannot lose that essential character that it has. So, whatever you amend, you must ensure that at the end of the day, it retains that basic feature. So, this argument of Peter Conrad and implied limitations was argued by the father of our former Attorney General, I forget his name, K.K. Venugopal's father. I don't know if anyone here remembers his name. But it was argued in this landmark judgment called Golaknath. In fact, even Fali Nariman had argued Golaknath, which is a bench of 11 judges, one of the largest that has been assembled. And Chief Justice Subbarao, when he passed a judgment saying that, you remember, law is defined in Article 30. He said constitutional law is that law in Article 30. Therefore, anything that violates that is the fundamental rights is void. So, it's basically Chapter 3 of the Constitution is untouchable. Now, this created problems because what if you wanted to expand rights? You could not do that by an amendment. Your Article 21A, right of education, becomes impossible to act because you can't even amend. It did say you can amend, but you cannot take away rights. It said you cannot amend. So Golaknath created certain problems which had to be resolved. And this is especially in the context that we had a lot of landowners post-independence, a lot of zamindars. And for any government to succeed, it was very important for land to be acquired or property to be acquired by the government so that they could do developmental activities. In fact, I think one of the Pakistani economists said that one of the reasons why we have fared much better as an economy than them is that they were never able to get their land reforms in place after independence. And therefore, a lot of the zamindars of the time are still zamindars. Whereas we were able to get our land reforms in place and thereby able to accelerate development. Now, that's of course a question of economics and politics, so I'll leave you to that, but that was the goal of the government back in the 50s, 60s, 70s to acquire different forms of property and nationalize it so that it could be used for greater public good. And a lot of the fundamental rights cases involved that. In fact, Kesan and the Bharti, which is the next case after Golaknath, 13 judges, involved such a land acquisition case where the property of this religious figure was taken away and therefore that was challenged. And the funny part is he never got his property back because that particular amendment to the constitution was held to be valid. But the judgment became a landmark judgment and laid down law. But actually, it's very funny that if you actually examine even Kesan and what Kesan and the Bharti said eventually, is it overruled Golaknath? He said no, you can't say that fundamental rights chapter cannot be amended. It can be amended. But it also rejected that doctrine of implied limitations. It said that no, that's not good enough. So it came up with a third slightly modified doctrine, which harked back to Justice Mudolkar saying basic features. So they use the expression basic structure of the constitution. Now what is this basic structure? There are a lot of being criticisms about this. Basic structure, they have given reference to the preamble. Now this is a guide, it's not an extensive indicator, it is illustrative. It says that anything which affects the basic features, such as democracy, republicanism, federalism. So let us say, let me give you an example now. This is, you all know what happened in the Article 370 case. Would anybody know what happened in the Article 370 case? What did the government do? Anybody would like to volunteer? Yes?
Except Article 371 clause, all other clauses of Article 370 were written by amendment.
No, not that. What they said is that Article 370 had this one saying that by a presidential notification, 370 may cease to operate. So they abrogated it. That's fine. But when abrogating it, they said something that basically Ladakh was made into a union territory, and Jammu and Kashmir as a whole was made into a union territory, right? So the question that arose, and which was not decided by the 5-judge bench, is that can you do that to a state? Can you take a state and carve it out into two union territories? Because if that's possible, what is stopping you from doing that to Uttar Pradesh tomorrow? To Maharashtra day after? Interesting question. What tomorrow if let us say Vidarbha is made into one, Konkan is made into one, and one more part is carved out somewhere, Marathwada is carved out, and you make 3-4 Maharashtra, 3-4 union territories, Mumbai is one more union territory. You have 4-5 union territories within Maharashtra, directly under the central government. Would that be permissible? If that happens under constitution? It's an interesting question. The answer is not out yet. But the doctrine of basic structure is meant to protect against such kinds of action. Because no constitution maker, so let us say you are in place of Dr. Ambedkar, Nehru, Vallabhbhai Patel, no constitution maker can anticipate every event that is going to happen in the future. Therefore, they leave enough sort of room in the joints so as to give future the future people an ability to move, to create policy, but at the same time safeguards. So this is a very nuanced question because we have had states where, for instance, Uttarakhand was carved out from Uttar Pradesh. Then Chhattisgarh was carved out of Madhya Pradesh. From Bihar, you had Jharkhand, which was carved out. So you have had cases where state boundaries are not set in stone. But that does not mean, I mean, we have to figure out where the line is, where it will affect the basic. Now, this has led to certain very important criticisms of the doctrine. That is basically judges deciding where the line is drawn. But on the other hand, who else can you trust with this? Can you trust the legislature? Can you trust the executive? Difficult to say. Rest assured, basic feature or basic structure is a doctrine that has worked to a large extent in India. It is being used extremely sparingly. It is not that every time something comes up, and it has gained widespread acceptance in other countries. So Supreme Court of Bangladesh is used, Supreme Court of Pakistan is used, Supreme Court of Kenya is used, and a couple of other countries as well. So it's an interesting doctrine, it will keep evolving. But what must be taken into account is basic structure doctrine comes into play only when you are talking about a constitutional amendment. Because if you remember, all other laws, the moment they are void, or the moment they are violating fundamental rights, they automatically become void. So for ordinary laws, the moment they violate fundamental rights, void. For constitutional law, the moment it violates basic structure, becomes void. Hope this dichotomy is clear. Now, what are the other ways in which you can declare a law as illegal? So one is fundamental rights. It violates fundamental rights, therefore it is void. What's the other way? Okay, I'll say it out. Basically, you are aware that we are a quasi-federal structure, right? So there is, in the 7th schedule of our constitution, there are 3 lists. There is the union list, state list, federal list. Perfect. Now let us say there is a union subject on defense, and the Maharashtra state government says, well, 2611 happened, my defense is not being taken care of properly by the sector, therefore I am passing a law on defense. Can they do it? No. So when you challenge that law, does that violate fundamental rights? Probably not. We don't know. I mean, depends. But let's assume it does not. How then you challenge it? Because fundamental rights is violated, is void. What's the other? The other way is legislative competence. So if the law is not passed with the competence, then it becomes void. For instance, if there is a state subject, like law and order, and the union passes a law, void. But this is with some restrictions. I won't get into that today. But the constitution provides that even if something is purely within the state system, the center can pass laws so far as certain constitutional requirements are met. Which is why, for instance, the Indian Penal Code can be amended by the center. You can have state amendments to that Indian Penal Code, but at the end of the day, it's a central law. But so that is one. Then another way in which you can declare a law is, let us say, I pass rules. So there is a preventive detention rules. Let us say. Now, the rules is what is a subordinate legislation. You are aware of what a subordinate legislation is? Raise your hands. Anybody? What is a subordinate legislation?
Where the constituent authority delegates the power to somebody else or a subordinate authority to form the legislation, and basically it's delegating the authority to act.
Perfect. So, for instance, you all were aware of the Citizenship Amendment Act? Yes? That was in news, right? Now, the rules to that act, the act was passed in 2019, but the rules of how it was to be implemented came in 2024, right? Now, let us say the rules and acts, there is a clash between them. That they say two very different things. What do you think? What will prevail? Why?
That is the parent.
Correct. So the assumption is that the parliament as a whole is a much superior body. It is to keep a check on the executive. So the parliament has passed a law that is superior to a mere rule, because that is just being passed by an executive. Therefore, if there is any inconsistency, or if, let us say, my rules go beyond the act. So now the act says only people who have come in till 2014, December 2014, can be considered for citizenship. Let us say the rules say all the way back till 1940 or till 2024. People who have come in till 2024, you can apply these rules. So if it goes beyond the scope of the act, also you can challenge it. Then there are a couple of, I think, very interesting forms of rights violations which one needs to consider when applying the test of constitutional law. There is indirect violation of fundamental rights. So one is direct violation. I take you up, there is no authority, I put you in the jail, or I shoot you. Violation of life, direct, on the spot, right? Those of you who have heard of ADM Jabalpur. In ADM Jabalpur, and I think for the basic structure context, this is a very important point. In ADM Jabalpur, one of the arguments that the Attorney General made was, even if I shoot somebody, if a police officer shoots somebody during the emergency, that person's family would have no recourse in law, even if there was absolutely no reason to shoot that person. And the court accepted the argument. In one of the worst judgments of Indian history, the court said, yes, during emergency, fundamental rights stand suspended. Therefore, even if there was no reason to shoot somebody, and you shot that person, they had no recourse in that. Now, many years later, ADM Jabalpur has been buried 7 fathoms deep. It has been explicitly overlooked. But this goes to show the kind of excesses that could be committed and why guarding the fundamental rights is so important. Which is why even after the emergency ended in 1978, we passed the 44th Constitutional Amendment. where he said that Article 20 and 21 of the Constitution can never be suspended, not even during an emergency. And Fali Nariman has argued in multiple places, not in a court, but generally as a scholar, that this is an implied acceptance of the Parliament of the basic structure. Because they have said that there is something in this which cannot be avoided, which cannot be taken away even during an emergency. Now, indirect ways of attacking your freedoms. So there is a whole host of Indian Express related judgments. Yeah, there is a whole host of Indian Express related judgments where suddenly one day, and I love your thoughts on this, suddenly one day they said that you are allowed to print only 20 pages of newspaper, nothing more. If you were a judge, how would you handle this? Indian Express went up and they said this is a violation of my fundamental right. I have a fundamental right of speech. They said no, but fundamental rights are subject to reasonable restrictions. I have restricted it to 20 pages. How would you decide? Anyone, come on. Common sense. I don't want you to expound constitutional law. Common sense. Why is it not reasonable? 20 pages. And you read not to see 20 pages. Better than having first four as advertisements. You do print news.
These restrictions are also defined in the law. It can only be doing in those heads.
Okay. What are the heads?
National security, public order, decency, morality, security of state, foreign relations.
Yeah. Yeah, you've got it right. I can define it, I can say it's in public order. Yeah. Wonderful. What's your name? Which year are you? Very nice, but very nicely expounded. And the court came exactly to this conclusion. They said that don't look at the what you call as look at the effect. Don't look at the action by itself. So don't look at it from the point of view of I am restricting it to 20 or 40 or whatever number of pages. What is the effect of this? And they put it in multiple ways. So one way of what she said there is a commercial interest of the newspaper to be alive. Because if the newspaper is not alive, how will it even run? How will it continue printing news? How will it continue to do its public duty? So that is one. And it said there is a commercial interest, so commercial speech is also part of free speech guaranteed under Article 91. So there is, it said in its judgment, the right of the advertiser to advertise in the newspaper is also a right under Article 19. The right to receive the advertisement and the money is the right of the newspaper under Article 19. So both ways it said. And generally, it has expounded that Article 19 works two ways. So if tomorrow the government says, I should not come here and be allowed to speak, it is not just violating my right to speak, it is violating your right as adults to hear me, which is a very important distinction, very important facet of Article 19. And if I create indirect means of stopping somebody from speaking by this restriction, in fact they restricted advertisements as well. In a separate one case was number of pages. In the other they said no, we believe it's getting too corrupted news media, therefore we are putting a ban on how many advertisements you can accept. That also was struck down. So this is one. Second, there was a list of customs and customs cases against the Indian Express, because that time the Indian Express against Mrs. Gandhi and then Rajiv Gandhi later they were constantly at loggers. So they were constantly criticizing the emergency, what happened after that, Bofors. In fact, during the Bofors scandal, Ranjit Malani famously published on the front page of the Indian Express 10 questions a day for 30 days straight. And I mean, that damaged the Rajiv Gandhi government like nothing. But and you don't see that kind of, I mean, imagine if somebody put 10 questions a day against the government. Yeah, unimaginable. But, so the Indian Express was constantly attacking the government. They wanted to find some way of attacking back. Now the building on which that existed was government building. It had been put on lease to the Indian Express. They said, we are cancelling the lease. We believe that you have violated the terms of the lease. Therefore, we are cancelling the lease. So, if you don't exit and demolish the building within, because the building had been constructed on the land which was leased out, and you have to give what is known as vacant possession. So, if you don't within 30 days demolish the building and go somewhere else, we will demolish it ourselves. The Indian Express building in New Delhi, and you have to pay this much extra rent, etc. And they put 1 or 2 customs cases, foreign exchange act cases on the Indian Express. All of this went to the Supreme Court. They said what you can't do directly, you cannot do indirectly. You can't indirectly also violate the fundamental rights. It is very important. So sometimes it may appear that something is being done under the garb of legality. They'll say, yeah, lease was violated, therefore we are evicting the person. But no, it's not as if the lease is being violated. You have cooked up a reason just to harass the person and violate the fundamental rights. And therefore, that is what. And this can be seen to some extent, although no courts have ruled upon it, in what in today's parlance is being known as bulldozer justice. That is not a punishment in the IPC. It is not a punishment in the Nyaya Samhita. But it is a punishment often meted out by executive authorities against those whom it believes have committed certain crimes. And that punishes the whole family, because demolishing that entire house or the hut that they are living in. And therefore, so it's an indirect or in some cases there is direct violation also of fundamental rights. So this is one. 2. Can the court violate a fundamental right? Because up till now we have been discussing, in the start we discussed state. And what does state mean? Of course it means the executive. But does it mean, it also means the legislature, but does it mean the judiciary? Can the courts violate the fundamental rights? What's the answer? Why? We say no. Why? But why can't it violate the fundamental rights?
Wouldn't it be ironic if the guardians of the fundamental rights are
Sorry?
Aren't courts supposed to be the guardians of fundamental rights?
Of course, they are supposed to be the police are supposed to be guardians of all of us.
Yeah.
But they violate our fundamental rights so often. So why can't courts, who are guardians of fundamental rights, violate fundamental rights? So this question was a very interesting question which came up in the Bombay High Court. And you can find a description of this in Bombay Bar Association. There is a lecture by Aspi Chinoy, which is called Beyond. It's basically a story. He will tell about his life experiences. In that he narrates this. Where this is a case called Naresh Mirajkar. In Naresh Mirajkar, the High Court said that somebody was recording evidence, cross-examination, etc. High Court said, whatever this cross-examination is, you journalists are not allowed to publish it in the media, in the newspaper. This is around 1976. So he said, the court has taken away my right of freedom of expression. Therefore, court has violated my fundamental rights. And he went to the Supreme Court. The Supreme Court constituted a 9-judge bench, and by a majority of 8:1, said that no, a court cannot violate fundamental rights. I am not fully convinced with the reasoning, but the court's idea behind this reasoning was that when they impose certain restrictions those restrictions are for carrying out justice. So it is to ensure, for instance, in the recording of evidence, that whatever evidence is recorded does not get wrongly transmitted out, or because of that, some pressure on the witness to testify in a different way. So when it is passing certain directions in furtherance of a certain proceeding, it can't take away your fundamental. And there is some sense to this, because if tomorrow you accept this argument that they can violate fundamental rights, then every case where they pass a judgment that is against the person and in favor of the state, you will say it's violated fundamental rights. So tomorrow if you are arrested and the court says no, the arrest is valid, they will say, oh, the court has violated my fundamental right, and it may open a Pandora's box to a lot of problems. But I think there is a solution somewhere in the middle, because I am not fully convinced, because a lot of times when the statute is a lot of times when the statute is vague or the statute is leaving some room, courts sometimes interpret it in a way that makes it very, very difficult. So for instance, a lot of the PMLA or UAPA cases, courts have really interpreted it in such a way that it becomes almost impossible to get bail. And that famous principle of bail not jail is not really maintained. So there are a lot of people sitting in jail who have not been proven to be guilty. So in such cases, maybe there is some line to be drawn to say, but this is an open question, you all can research about it. But as the law stands today by a 9-judge bench, no court can violate a fundamental right. And also this is very interesting, how can you overrule a judgment? So let us say a court passes a judgment, 5-judge bench, 3:2. Can tomorrow a court come and say, again 5-judge benches, can reverse that decision, 3 saying now the other way and 2 saying this way?
No.
Why not?
What depends on the total strength of your bench in totality, not the number of dissenters and agrees.
Perfectly. So if a 5-judge bench has held something, it could be 4-1, 3-2, 5-0, does not matter. If you have to reconsider that position of law, you have to constitute a 7-judge bench. If a 7-judge bench, then okay, then you go to 9. So you have to constitute a larger bench to deal with those issues. You cannot, and that is, the largest bench has been 30 of cases in the Rajya. But any such question, you have to constitute a larger bench. You cannot intercept play with the majority. You cannot say last time the 3-2 tha, now we'll make it 4-1 the other way and therefore overrule. No, not allowed. Okay, so that is one interesting point. Then, what are the other couple of things which I saw, which I thought we must do? Okay, yes. The proportionality topic, I think that was very important. There's 2 things that you must know. One is I can't get it here. But the idea is that when you say that there are reasonable restrictions, there is 2 things to consider. Okay, 92 says that, or 92, 3, 4, etc. says that you can abridge fundamental rights so long as there are reasonable restrictions related to public order, morality, friendly relations with neighboring states, security of state, defamation, and one more, something like that. Content. So, how do you define this reasonable? So, over a period of time, they have developed a doctrine. And firstly, what needs to be done is, if you're testing a law, and you can say this out in your court competition if you are a respondent, okay, then there is a presumption in constitutional law that any and every law is presumed to be valid until proven unconstitutional. So how there is a presumption of innocence and then there is a presumption of constitutionality. That goes very strongly in favor of respondents until you find. Now, if you are a petitioner, your duty is to show that fundamental rights have been violated, and then the burden of proof shifts. Once you prima facie show that fundamental rights are violated, burden of proof goes back to the respondent. And the respondent now has to show that it falls at that one, it is not violating fundamental rights, or two, even if it is violating fundamental rights, it's a reasonable restriction. How do you do it? So courts have developed tests. Court's first test is that it must be a legitimate aim. So the goal that you are trying to achieve by bringing out this law must be a legitimate one. So something like, let's say, national security, public order, one of those things that are defined under 1984. So that's first. Second, there must be a rational nexus between the object sought to be achieved and the law that is being passed, the action that you do. So you can't just say national security and then court should accept whatever you are saying. No, that can't be. There must be something logical between what you are doing towards the goal that you are trying to achieve. First is legitimate aim. Aim itself should be legitimate. You can't just do whatever you want. Two, a rational nexus between what you are setting out to do and what you want to achieve. Three, necessity problem. What you are doing must be necessity. If it's not necessary, then find a better way of ensuring that fundamental rights are not violated. Necessity prong is very, very important because usually the first two they are able to show the statements of objects and reasons that is there in the top of the act and go by. But they have to show that what they are doing is really necessary. Finally, and fourth most importantly, they have to show that this is the least restrictive way of going about this. So, for instance, if they were to block the roads, like in the farmers' protest, they are violating the farmers' fundamental rights to travel freely throughout the territory of India. So then they must show that when they are digging that road and putting iron rods and spikes and all that, that is first achieving a legitimate aim, two, rational nexus between what they are seeking to achieve and the goal sought, three, it is necessary to do so, and four, it is least restrictive. And this applies in so many other places. So for instance, when you, so many protests, you block off the internet. A lot of governments do that because they don't want the information to flow and there to be some riot or something. The aim is legitimate. You don't want panic to flow and people to start rioting. But then, is that the least restrictive way? Is there a necessity? Or let's say you impose 144 orders. 144 is curfew. No more than 5 people can gather at a given point of time. And in fact, actually on curfew, there is a very interesting judgment, which again Aspi Chinoy talks about in his lecture. He says that in the 70s, there was during the emergency, a 144 order passed. And it said that you cannot even have that gathering in a private place, not even public. It said private place also you can't have 5 people gathering together. And obviously, it's a myth that Muslim women have 4 wives. Most of them have just one. There's very little even bigamy that is practiced. So let the next joke, sort of light-hearted joke, not mislead you. But they said that theoretically, if a Muslim man had 4 wives, then he and his 4 wives also could not sit for dinner because they would be violating the 144 order. If that 144 order would be applicable to private places. So it's not applicable to private places, it's only applicable to public spaces. But that also you must show all of these prongs. So that is all. So in all your 19 cases this becomes very important and 21 cases this becomes very important. You have to show these, satisfy these 4 tests if you are a respondent, and you have to attack on these 4 if you are the petitioner. Then 14 also becomes very important. 14, there are 2 doctrines that you must know. One is reasonable classification and the other is manifest arbitrariness. Reasonable classification I will give by way of an example. You all know the CA Act, Citizenship Amendment. It said people who come from Pakistan, Bangladesh and Afghanistan. Now they say that you can treat people differently because the idea is, so there are two ideas. One is what is known as intelligible differential, and I think the other one is reasonableness. So the idea is that basically you treat equals equally and unequals unequally. That's the basic idea of Article 14. So if I am saying that if I make a classification that all the boys in this particular class will be, or particular room will be treated in one way and girls treated another way, then perhaps I could maintain, as long as it's not otherwise wholly arbitrary how I am treating people, I could maintain that okay, these are two separate classes, therefore I must treat them differently. Or let us say I could do it as first year student, second year student, third year student. Reasonable classification. But if I just randomly take 5-6 people from here, 5-6 people there, and say, okay, this batch I will treat like this one quadrant I will treat like this, that one quadrant I will treat in a different way, then there is unintelligible differential. There is no rationale behind how I am differentiating. And therefore, when the government does that, that becomes arbitrary. That becomes unintelligible classification. So that test is very important. There is a very famous judgment, Anwar Ali Sarkar, and then after that another one called E.P. Royappa. So you can have a look at these judgments. I don't have the citation, but like literally you put it on Indian Kanun and you will get the whole thing. E.P. Royappa and Anwar Ali Sarkar. So which laid down these tests. And then later on Justice Nariman in Shaira Banu has come up with a greater standard. He has come up with a standard called manifest arbitrariness. That is where on the face of it, it appears to be so absurd, so arbitrary, that you hold that law to be, that basically there is no way you can classify, there is no way you can even think of any such sort of thing. It's just on the face of it, completely unjust. And he used it in the context of the triple talaq, when he said that the concept under section 2 of the Sharia Act, that a Muslim man can just unilaterally give divorce in one incident by saying that talaq 3 times is manifestly arbitrary. So he used that and declared, and subsequently that doctrine has been used. Another facet of 14 which is very important is non-application of mind. So which again is a facet of arbitrary. So if let us say tomorrow your municipal authority wants to pass some tender and says that L&T should be building this flyover. Now, if that tender is passed and let us say it is passed for 20,000 crores, just like that, when the actual cost would be 1,000. Completely fictional example. Now, when such a thing happens and somebody, let's say, challenges it, then you examine whether that person who gave that tender out had examined their mind on how much cost will be taken, etc., and who should be given the tender, whether the process was fair. And if you see that there is no application of mind, it's just completely arbitrary. Just about anybody was given this. Or that bridge, which you remember was built, Morbi Bridge in Gujarat. It was built on the Sabarmati River and it was given to some party which had never built bridges in their life. They were building some printers and faxes and all that. They were given the tender of building a bridge and maintaining that. And it fell down into the Sabarmati River. Tons of people lost their lives. Now, this smacks of arbitrariness and non-application of mind. You can strike that as violative of Article 4. So, all of these are challenges or ways of attack of laws. Whether it's legislation, whether it's subordinate legislation, or whether it is constitutional law. With constitutional, of course, you can't use manifest arbitrariness, then you will go into basic structure. But these are the different ways in which you can attack all this. And with respect to, I'll quickly wrap up, but with respect to, so that if you have any questions also you can ask. But with respect to how you approach moots, I think what is important is read the fact sheet 5, 10, 15, 20 times. Because the facts entirely govern how you be a master. Prepare necessarily, like the date of something that happened, what event happened on that particular day, so that you have a full chronology of what has happened. And once you are a master of the facts, you will know that okay, this happened, as a consequence this happened. You will be very familiar with the words that are used in the moot proposition. So that's number one, and you can then apply the law to that given facts. So this is one. Read the facts umpteen number of times. No number of times you read it is sufficient. And sometimes take like your mind off and go back to it after some time. You will discover that you are reading it from a fresh perspective. So that's number one. Number two, just be familiar with broad principles of constitutional law. The reason why I am saying this is that as judges, there are different kinds of judges. Some want a citation every single sentence that you speak, and some want just an understanding that you know what you're talking about. And as long as you are referring to if you're sound in your mind as to the principles of constitutional law, if you use words like intelligible differentia, reasonable classification, understanding what it is, then the person knows, okay, this is what, you know what you're talking about, and therefore they will move on. They will not ask you for a judgment. They will not say, please cite judgment on well settled law. No, unlike. So be familiar with those, and then you will be, when you are reading the facts, you will be able to apply that accordingly. Then, whenever you are dealing with any law which is to be declared as void, pick up the law and read it properly, and have a copy of it to give the judges. So, if let's say it's an environment notification, then have that ready. If it's some notification passed by the municipal authority, have that ready. If it's a rules or regulations or an actual statute, have it ready with you. Examine it, and on different principles based on what the proposition says. Then look at the parties. Very important. I remember one of the land moots only. The MCA had, whoever was there in my time, not you. The MCA had, when drafting the problem, only kept, this was based on the coastal road zone regulations, 4-5 years ago. And that time they had made only the state the party. The BMC was not a party. The coastal road zonal authority, CZA, that was not a party. Only the state of Maharashtra was a party. I was a respondent. And until the final, even I had not thought of this implication. Then suddenly I'm literally, the judges are like coming up and I'm like reading the problem again, and like only the state is a party. So then I realized I can use this. I said, my lords, the petitioners have impeded only state of Maharashtra. They have not impeded BMC, they have not impeded this, they have not impeded that. Therefore the reliefs, because what at the end of the day, what are you seeking? I'm sorry, we didn't cover rates. But you are seeking a mandamus, you are seeking an order that so-and-so authority had a public duty to perform. They have not performed that public duty. Please direct them to perform their public duty. But if you don't put them in your petition, how will you direct them? How will you hear them? Audio alteram partem, natural justice, the right of a party to be heard. So if you don't complete the party, you can't hear them, you can't pass orders against them. Now this is a very practical thing, which you may miss otherwise. But keep very much tight focus on who the petitioners are, who the respondents are. Another thing, sorry, again this is something that if we start discussing it, we can cover at length. But as the petitioner, the concept of locus standi. Can you as a petitioner file on behalf of XYZ? Can you file on behalf of yourself? Can, let us say, I file on behalf of a minor who is not a next of kin? I am not a guardian of a kin. Can I file?
Yes. they are qualified entities.
But I have to show some law of itself. But the point is that, and locus standi has been diluted over a period of time. But that must be true. Then, so maintainability is a very important factor. So keep, whenever you are looking at it from respondent or petitioner side, please look at maintainability. And maintainability from 2 points. One, do you have locus standi? Who are you? How are you, your fundamental rights, how are they affected? Or how are the fundamental rights or other rights of citizens affected? 2, if you are a respondent, then can reliefs be sought against you? Or if certain other authorities should have been included, failing which the writ petition is ineffective, infractions. That's 1. 2, limitation. Now, the law of limitation as it stands is not strictly applicable to this. So like, if you have to file a suit, 3 years, whatever is in the schedule of the Limitation Act. Writs don't have that, but you can't come too late. So if there is unreasonable delay on your part, the judges will want to know what is the cause of that delay, and if you can't explain it, they might show you the door. They might say that no matter how good a case you have come to us too late. So there is no hard and fast rule there, but you may have to show that. Let's say the facts say that some event happened in 2016 and you are filing a writ in 2024. A smart respondent, if you are a smart respondent, you will bring this up. You will say your judges should not hear it on grounds of limitation, and the petitioners will then be on the back. Or the petitioner, you must prepare from the facts some reasonable explanation. Don't assume facts, but some reasonable explanation from the facts as to what could have been the reason why there is a delay. So that's very important. Then, then what are the reliefs sought? And again, who can you seek reliefs? Can you seek a mandamus against the President of India? Can you seek a mandamus against the governor? Check this out. I'm just leaving this as open-ended for you to check up on your own time. But can you seek a mandamus against the Parliament to pass a law? So like for instance, there is no same-sex marriage law in India. Can the courts direct the Parliament to pass a same-sex marriage law? Check out. I won't tell you the answer. But these are interesting questions of law which we will have to grapple with in any constitutional problem, law problem, and with particular reference of course to the problem that you will be concerned with. Then what else? Then of course whether it's 226, 32 you will have to look at which court it is before. I think that is it. Yes, there is one thing that I forgot to mention, which is actually very interesting. But you are aware that difference between fundamental rights and directive principles, right? So fundamental rights are enforceable in court. Directive principles are not enforceable. Now, and 2-3 sort of interesting trivia. Yes. So one is that in the 1970s, during Indira Gandhi's time, they passed one constitutional amendment which said that if a law is passed in furtherance of a directive principles of state policy, you cannot strike it down saying it's unconstitutional. And subsequently, Minerva Mills versus Union of India, that amendment, that constitutional amendment was struck down, saying that you can't take away the power of judicial review. Judicial review falls under basic structure of constitution. So the court will still have the power to examine whether a law is constitutional or not, irrespective of whether it is done in furtherance of directive principles. This is one important point. Second, can a high court call a central law to be unconstitutional? A high court generally has its jurisdiction over the state. So the High Court of Bombay has its jurisdiction in the state of Maharashtra, Goa, Daman and Diu, Dadra and Nagar Haveli. Can it declare a central law unconstitutional? Any thoughts? the answer to that, and I think again this was Minerva Mills or a subsequent decision, that initially yes, you could, it's a constitutional court. So therefore, not just it could strike down a central legislation, that striking down would be applicable throughout the territory of India. So today if I strike down, Bombay High Court strikes down the information technology rules of 2023, that is applicable not just for the state of Maharashtra, Goa, etc. It is applicable throughout the territory of India. It is void for the entire country until of course the judgment is in appeal affirmed or rejected by the Supreme Court. Number one. So what they did was, during the emergency, they passed what you will now not find in the constitution, Article 226A, and they took away the power of the high courts. They said high courts can only look at state laws. They cannot consider whether a central law is legal or illegal. By the 44th Amendment, once Indira Gandhi went out of power and the Janata government came, they deleted that article. So that was extremely short. 77 was 42nd Amendment, 78, 79 was the 44th Amendment, and it was brought down. So now again, high courts can examine central legislation. Then one interesting thing which I found out while preparing for this workshop. You know that there are fundamental duties which have been incorporated under Article 51A. Are fundamental duties justiciable? Can you enforce them? I thought so too. So here's the twist. You can't enforce them in a writ court. You can't file a petition under 32, you can't file a petition under 226. But if somebody violates their fundamental duty and you can show that you have been affected by that, you can file a suit under Section 9 of the Code of Civil Procedure. The reason being that Section 9 of CPC says that you can file any suit and no suit shall be barred unless there is a statute expressly, a law expressly barring such suit to be instituted. Since there is no statute barring institution of a suit for fundamental duties, if those are violated and you can show yourself to be affected, you can file a regular suit against such person. So this is something new that even I came across.
So can we consider a violation of fundamental duty an indirect violation of a right or
No, I don't think it's a direct or indirect violation of fundamental right, because if you see the nature of the duties, it is like standing up for the national anthem and keeping a scientific temperament, those kind of things. So I don't think you can call it that, but it can definitely be a violation of a common law right, or a violation of a constitutional right, but enforceable by way of a regular suit. I mean, quite frankly, I am also trying to wrap my head around this, and I am taking the word of Fali Nariman on this, because so there is a very nice book that is written, which I was referring to, called "You Must Know Your Constitution." Very recently it's been published, and I was going through that to see what I can cull out from that and share with you guys, and this is referred to in that. And I'm not fully convinced by this, but there seems to be some sense to what he's saying. So you might examine it further and maybe write articles on this, either disproving it and saying that no, he's completely wrong, or saying that no, he probably has a point, he's right. But something worth exploration, that fundamental duties which we thought to be not enforceable are funnily enough enforceable. So on this note, I think I'll conclude. If you have any questions, I'll be happy to answer. It could be connected to what we've discussed, it could be something completely different, it could be on recent constitutional cases that you have been that has piqued your interest. Anything? No? Okay. Thank you.
so that I have
Yes, sure.
during the question with regards to application of Article 370.
Yes.
And accordingly, the limit territories cannot be formed later because you somewhere question the basic structure of it.
Yes.
But then Article 3 and Article 2 were granted these powers to the Parliament, and how is it questionable for us to raise this particular question of basic structure of
So,
adding on to that, Dr. B.R. Ambedkar said, India is a union of India is an indestructible union of infinitesimally destructible states.
Yes.
So isn't this particular process justified in law?
So let me put it this way. You always think of it, you take you take an argument and you stretch it to its logical conclusion. If India is a union of destructible states, where you can keep changing the boundaries of the states, can you make all the states of the country part of like a union territory and make them as part of the union in that sense? Can every state in India become a union territory? Can we do that? Because Parliament has power to amend the boundaries of states. So, using that power, I amend all the boundaries and remove them. And I say there is one state. What are the implications? The implication is your entire list 2 goes away. When you are correcting GST, CGST and SGST, all your revenue provisions of state GST go away. Your power of correcting revenues in terms of this one, what is it? Alcohol and this one, petrol and all that, go away. Police, law and order, all of that will now come under control of central government. State police will cease to be a thing. You will have a national police now. So the implications are so far and wide that when we think about it as to what the basic structure is or what would our founding fathers have thought of, this seems to be too drastic. So where that line is, so if you want to change the boundary of a state and say that boundary should not be here, it should be here, it should be shifted. Or maybe you make for administrative reasons one state into two, like happened with Madhya Pradesh, Chhattisgarh, Jharkhand and Bihar. Okay, that is fine. But can you say Bihar and Jharkhand will cease to be states, they become union territories? Come on. Does the power extend to that? So that's what the courts were struggling with for the longest time, and probably still will struggle, that there is that unlimited power in the sense that there is a lot of power of the parliament, but that limitation is either inherent limitation or implied limitation, or it is some sort of a basic structure that you can't sort of deface and defy the constitution. So you have to keep the federal structure intact to some extent. And even in the case of Jammu and Kashmir, Article 370, the reason the court did not decide the issue, and they have said that in their judgment, is that the Solicitor General of India made an assurance that the statehood would be restored and elections would be held in, not for Ladakh, but for Jammu and Kashmir it would be held within I think 6 or 9 or 12 months, something like that. He gave a time limit. Now, basis this, the judge said, okay, then we are not deciding this question. Justice Nariman, now retired, raised a very interesting point on this. He said this was an issue before the court. The court ought to have decided the law on this and made it clear. So then we could discuss whether an entire state could be carved out into 2 union territories and completely removed from, now it's no longer a state, just 2 extra. So we could have had law on that. Now that is sort of legal, like a black hole. We don't know what exactly the law is. It's unclear. 2. Can the Solicitor General statement, who represents the Union of India, that is the executive, bind the Parliament? And that was future Parliament, because the case was decided in 23. After that you have had general elections in 24. How can the Solicitor General of India presume that the next Parliament will pass a law and give an assurance that the next Parliament will pass a law bringing back the states? You will have to pass a law saying that the current union territory of Jammu and Kashmir becomes a state and therefore we are holding elections. Now, this is an interesting question, and I think probably not. I don't think the Solicitor General has that authority. And possibly the court should have adjudicated. They could have adjudicated saying yes, there does exist power. They could have said no. Possibly the basic structure doctrine comes in the way. They could have ruled either way. But at least we would have got something from them. In fact, I think you can follow. There's a blog called Indian Constitutional Law and Philosophy by Gautam Bhatia. And I sort of subscribe to that and we keep reading from that. he has come up with two terms which he says that in the last 10-15 years has been the dominant theme, that, or at least last 10 years. He has said that one theme is being more executive minded than the executive. So what you do is, you don't decide the issue for the longest time. By not deciding the issue, whatever the executive is doing, in effect, that becomes a decision. So if you delay a decision beyond a point, you can't take back, you can't turn back the clock. Like, I mean, you can do it to some extent, but not unlimited. So after a point, the longer, the more the time passes, the decision becomes sort of like nothing that the court will say, it becomes instructional. Nothing that the court says or does will change things. So one thing is that whenever the executive takes such action, it is important, according to him at least, that the court decided quickly. Otherwise, in effect, it is making a decision in favor of the executive by not deciding. Second is this thing known as lawfare, and I think you must come to terms with it. It is very similar to the indirect violation of fundamental rights that I was talking about. So you use the law to target people and say that, well, the law will take its own course, but the law taking its own course might mean process becoming a punishment. So if I put somebody in jail under the UAPA, PMLA or other such laws, NDPS, all of these, you languish in jail for 6 months, 1 year, 2 years, and for getting bail you have to satisfy that you are not guilty of the crime prima facie. It becomes a very difficult burden to satisfy, or that you will not commit a crime when you come out. So by using this, governments have been, so he has coined the term lawfare. That is, instead of warfare, lawfare. You use what is otherwise seems on the face of it to be legal to do something which is sort of harassing citizens and thereby violating fundamental rights. So you can look him up, read him, and form your own views. I don't intend to. In fact, very interestingly, he publishes views which are guest blogs, which criticize him also. So recently, he wrote a blog on one of the court's orders, the Arvind Kejriwal bail order. So he had written a blog criticizing the court. He had said that it's 8 pages of unreasoned judgment. And somebody said, no, Gautam Bhatia is wrong. Some student, I'm talking about, not a lawyer. Some student said, no, Gautam Bhatia is wrong, and I feel that I should respond. So he wrote a detailed blog, and Bhatia was gracious enough to publish it. So that rebuttal blog is also there on Indian constitutional law and philosophy. So if you examine certain constitutional questions, you can explore them, research them, write about them, and publish it there. So all the best, and I think that's it, unless any more questions. Yes. Yes. No, I would slightly disagree. So first is what the court did is, and there are 2 bail orders. So one is the interim bail order that was passed releasing him during elections. Then there is a subsequent bail order that's been passed now. Both are interim bail orders. Now nowhere in your CRPC or the new law you will find the word interim bail. That's not defined anywhere. But what they reasoned was that under the constitution, there is nothing to say that if you are, just because you are arrested, you should stop holding office. So for instance, one of these fellows called Amritpal Singh contested an election sitting in jail in Manipur or some such place. So in the northeast he has been imprisoned, but he has not been proven guilty. And someone like a Rahul Gandhi, who was proved guilty in the defamation case, criminal defamation case, because there is a stay on that judgment, he can fight elections. So the criticality test is whether somebody has been convicted. not whether, and therefore whether they are eligible to be a member of legislative assembly or member of parliament. As long as they can be a member of legislative assembly or parliament, they can hold office even if it's a chief minister's office. There is no constitutional bar on that point. Now, what the court said in the first interim bail order, they said it's going to be very difficult to decide the issue. It's a complicated issue on what is known as section 19 of the PMLA. Not really a constitutional law issue in that sense, but in some ways also it is, because Abhishek Manu Singhvi said that the fact that Arvind Kejriwal needs to be out campaigning during general elections is to maintain a level playing field, and maintaining a level playing field, he argued, is part of the basic structure. So he invoked that, but it's basically 19 of PMLA says that if I am arresting you, I as an investigating officer need to have reasonable grounds to believe that you are guilty. And if, let us say, there are 3 statements which say that, sorry, what's your name? Urmi. So if there are 3 statements that say Urmi is guilty, and there is 1 statement that says Urmi is not guilty, can I, or whatever, there are 4 statements that say Urmi is not guilty. What do I do? Do I balance these 2 conflicting statements, or do I rely only on the statements that say you are guilty? Now this is an open question which the Supreme Court will decide. So this is literally the question that the court has to decide under 19 of PMLA. Until that decision comes in, and they have referred it to a larger bench. Until that decision comes in, they have said we have 2 options. Either this fellow stays in jail for that time, or he is out. Correct, but the reason for that is what? The reason for that is that he is not asking for bail. He is saying my arrest is itself illegal. He approached the Delhi High Court under 226 and said the arrest is illegal. So it was a 226 read with 19 of PMLA. So if the arrest is illegal and he spends all this time in jail, he would have been wrongly imprisoned if they finally decide. So there is in both civil and criminal litigation, there is always this with whom the balance of convenience lies in interim orders. And the balance of convenience, they said, lies in protecting the liberty of, it need not be Arvind Kejriwal, it could be any Tom, Dick and Harry. But the idea is that if you have to choose between keeping somebody in jail and letting them out until a law point is decided, and you know how much time courts take to decide points of law, then it's better in the larger scheme of things to let the person be out. And when that person is out, if there is no disqualification in terms of being an MLA, MP, etc., then he can hold all the offices that he otherwise holds. So they have not said he can do whatever he wants or he cannot do whatever he wants. They have just said that whatever is the par for the course, whatever is the norm, that continues. That's all. Anything else? Thank you so much.
On behalf of the Moot Court Association of Government Law College Mumbai, I would like to thank Mr. Sreenivasan for conducting this excellent workshop on the constitutional law. And like the audience members, please be seated and we escort Mr. Sreenivasan. Okay. Thank you.
Thank you.